Today, as everybody is aware, there was a time when our clients, the famous Kianjokoma 6 police officers, were charged with the offense of murder. The state objected for them to be released on cash bail or on bond. The family stood with their own children and their sons and daughters, the fathers and mothers, aunties, wives, children who are present here, instructed us to move to court to seek for bail for our clients. We filed for an application for bail. We equally challenged the decision to charge the 6 police officers contrary to section 387, which demands that if anybody dies within the hands of the custody of the police, an inquest is mandatory. The state bulldozed and they were charged. After they were charged, we applied for bail. The state raised several reasons as to why they cannot be released on bail. One of them being that they will interfere with the witnesses. The court has looked at that and agreed with us. Those police officers are already interdicted and they do not exercise police powers, and therefore they cannot interfere with the witnesses. The second other ground they raised is that these officers are likely not to come to court. We provided evidence and the state agreed with us. There are very many reasons the state provided for. The court has dismissed each one of them. And in compliance with Article 49, 1H, the officers have been released on cash bail and bond with serious conditions. We wish to say this is a landmark judgment ruling on the basis that the cash bail that they have been granted is a representation of their salaries. It has been staggered. These are constables, mere police, one police corporal. So the court has listened to us and agreed with us and entered them in reasonable cash bail. It is a serious indictment on the office of the DPP. Why does the DPP waste so much time on pre-trial detention? The DPP has put so much pressure fighting for the people not to be released on bail. And as defense team and as the citizens, we are saying every other time the courts are standing firm to say that the grounds of Article 49, 1H, unless there are compelling reasons, everybody is entitled to bail and to bond. Whether it is a policeman, everybody is entitled to the rights and protection of the law and the constitutional provisions. So for what you are seeing, the police force also have benefited for the protection of the constitution. 2, we are also raising this question. The argument being projected all over that these 6 people murdered, we stood here and put it very clearly that these are mere allegations. The 6 police officers did not murder the 6 Kianjokoma boys. The 2 deceased young men, I sympathize with them, I pass my condolences, jumped from the vehicle. They met their death. The aspect of civil society trying all over to bulldoze the director of public prosecution and to charge everybody just because civil society wants to make money, to make funds, to receive donor funds, that they are prosecuting, people are innocent. It's a serious indictment. And this must stop. Let the DCI, let the DPP work outside the civil society. Kenyans are being denied bail because of the pressure from the civil society. The court has ignored the civil society. The court has looked at a proper interpretation of Article 49, 1H. The court has listened to the facts. The court has seen the parents who are here and has released the police officers. And to me, as a practicing advocate in the criminal court, I do appreciate the interpretation of the court. In line with this, another landmark ruling was delivered by Justice Nsioka on the question of mental assessment. The ruling is likely to be out today. We raised the question in another police matter where a police officer was charged. He's supposed to be charged, and the state wanted him to undergo a mental assessment. We raised an objection because it is not based on any law. We argued the matter. The judge on Monday gave a landmark ruling saying that mental assessment is not mandatory. It is optional. So I hope the state and the DPP, if it do not appeal, it is no longer part and parcel of the process of somebody taking plea. It has been a system that that clogs the system, and we have a backlog for nothing. For the criminal courts to move forward and have no backlog, my proposal and the law firm of Musyoki Mugaka's proposal is one: there is no need to oppose bail. Let everybody be granted bail. Upon that person failing to comply with the terms of bail, then the police will arrest and cancel that bail. The DPP is listening. Number two, on the question of taking people for mental assessment, the court, Justice Nsioka, has pronounced that it is not in any constitutional provision, nor is it in any statutory provision. They are practices and customs not known in law, so therefore it is not law. That way, with those two landmark rulings, one by Justice Ogembo, Daniel, we appreciate the interpretation of Justice Ogembo, and we appreciate the judgment and interpretation of the principal judge, Justice Nsioka. We intend to see government action from the office of the DCI and the DPP implementing that, and everybody is equal before the law.
What are the terms?
Is a cash bail of 300,000 shillings or a bond of 3 million shillings, which is reasonable and fair. For the Jogoo Road matter, I'll discuss on it tomorrow. It's still ongoing. We'll deal with it then.